Okay, so in this lesson we are going to review more sales contracts, and we've already had several videos on this, so if you need to go over it again, this would be the video. I'm going to go kind of quick on this because we got 7 lessons, just like the last lesson. It is 7 lessons and a 10 question test. We're going to try and get all this in under 30 minutes. The seller is responsible for paying for an inspection? No. The wood destroying inspection can be conducted by the seller? No. The wood destroying inspection and report are optional? I think they are optional. Garages are not included. I don't know about that. The seller must pay for repairs or damages regardless of the cost. I don't know about that either. If the treatment or repairs exceeds 2% of the purchase price, the parties have the option of canceling the contract, maybe. I got all these right, too. How about that? Oh, my God. Okay. To repair or not to repair? I mean, how many days from the time he receives the point report does he have to get these repairs done? I mean, I want to say 5 days, but I have no idea. Let's see if it tells you on here. Nope, it says more of these tiny things. Okay, I'm going to say 5 days. That's right, 5 days to notify the buyer of his decision whether he's going to fix stuff or not. All right, basically the seller must have to pay for the treatment and damage repairs, and it cannot exceed 2% of the purchase price. Okay, the deposit, deed, and title. Like I said, we're going to be going kind of quick because we got 7 lessons to cover. All right, the earnest money deposit is not put into an escrow account until after the buyer and seller have reached an agreement. I want to say true on that. If the seller does not accept the buyer's offer, the earnest money is returned. The earnest money is credited against the buyer's closing costs. If the seller does not occur, if the settlement does not occur and the contract is terminated, it's returned to the buyer. No, it's not returned to the buyer, okay? The buyer and seller must sign a release of deposit, and it's executed by the broker who is handling the escrow amount, okay? All right. Basically, it is going to be returned to the buyer eventually. So after the broker approves it, then it'll get returned to the buyer. The seller must transfer the property deed to the buyer once the buyer has paid the purchase price at settlement. In Maryland, property is conveyed with a general warranty deed. The title of the property must be in good, aka marketable, as well as insurable without any risk premium. It is understood that the title may be subject to commonly accepted easements, zoning laws, or recorded documents. If the seller cannot provide a title that is free of defects, the contract is automatically terminated. Brokers and agents are liable for defects, no, in the seller's title. No, we are not liable for anything like that. Okay, so it is conveyed with a special warranty deed, not a general warranty deed. Okay, so it's true, false. And this one is false. It is not automatically terminated. Okay, I guess that makes sense. If it has defects, you got to try and work through these defects. I knew these true or false, so I'm going to go that way. All right, this is false. Okay. Normally I would scroll through this slow for you, but we got 7 lessons, so we got to move kind of quick. What happens if the title has defects that the seller is unable to remedy? The buyer has the option of accepting them with defects and canceling the contract. Correct. All right, taking title advice. Because a title can have significant legal and tax consequences, what does Kiara advise them to do? Seek professional advice. All right, deposit and deed and title sections recap. Okay, so The buyer's earnest money is deposited into an escrow account, and once they reach an agreement, it is held there until settlement. If the contract should be terminated, the earnest money is deposited and dispersed in accordance with the release of deposit agreement from the broker, because the broker is holding on to that money in an interest-bearing account, and they have to account for that by law. If they can't show where the money is or how it's been deposited or released, then they could get in trouble. They could get a hefty fine. When is the seller required to deliver possession of the property to the buyer? At settlement. The seller is under no obligation to keep the property in the same condition it was at contract acceptance. False. The seller is required to deliver the property free of clear trash, broom clean when they leave it. And if one of the property fails, if like one of the systems fail, that's no fault of the seller. The seller is not required to fix it if it's not their fault. Unless there is something the seller needs to fix prior to the inspections, the buyer is agreeing to purchase the property as is. All right, this is false. So if one of the things fail, they have to fix it. All right. At the time of the contract acceptance, if it was, this is false, true, this is false. And the buyer must accept the property. Unless there's something to fix, the buyer agrees to buy the property as is. Okay. Final inspection time frame. How many days before seller does the buyer have a final inspection of the property? 3 days. Okay. You have 3 days to make a final inspection of the property. Okay, never mind. It says 5. Okay, 5 days. Make a final inspection and 5 days before settlement. The seller has to maintain the property and contract acceptance. Okay. Settlement costs, transfer section. Okay. Identifies miscellaneous charges that must be adjusted to the day of settlement. Specifies the fees associated with the sales transaction and the buyer must pay. Identifies which party is responsible for the transfer taxes. I don't know. Let's guess here. Miscellaneous charges that must be adjusted. And I got it all right. Well, this one says adjusted. So if you get this on a test, then you can that kind of makes sense, right? And this one I think says transfer in it, so that's why I picked transfer. Some of these are just common sense. Okay, read each of the items and determine if a charge needs to be adjusted or not. Taxes may be adjusted. Deed preparation, no rent. Assessments against the property, yeah. Homeowner association, maybe. Okay, so this is yes too. It looks like all of them could be adjusted at settlement. And some of these make sense because, it depends. Like if your settlement date changes, then some of these could change depending on what day you close. Didn't we just do this? Okay. Read each of the follows and decide whether a charge needs to be adjusted. Did we get it wrong? Is that why it's doing it again? Oh, deed preparation is a fee that must be applied by the seller. It's not adjusted. Okay. My goodness, I looked at this already. Okay, encumbrances or title defects. Who pays what? Now, a lot of this is done by the mortgage company, but it's good to know these things. All right, first time home buyer state is going to be the seller. Certain charges of the VA financing, seller If you're going through the VA, usually, if you're a veteran, you don't have to pay anything. Insurance fees, the buyer, according CV, loan insurance premiums, title defect clearance. I'm thinking that's the seller. Good job. All right. So adjustments, transfer charge recap. Moving right along. Okay, broker liability fees, seller buyer responsibilities. Okay, the brokers assume no responsibility for the property's condition. I don't know about that one. Hold on. All right, let's go down here. States that the buyer must make no false representations regarding financing. States that the seller must transfer the property to the buyer free of any issues. States the settlement agent will disperse the broker's compensation. States how the settlement agent will disperse the broker's compensation. And this one is the brokers assume no responsibility for the property's condition. Who is charged with dispersing the broker compensation? The settlement agent is. Okay. Brokers are responsible for their client's performance of the contract. This responsibility extends to the subagents, employees. Buyers and sellers have the responsibility to know and to hear what's written in the contract. The seller is responsible for keeping the title and property free of defects until the buyer buys it. If the property is damaged or destroyed within 5 days of settlement, the buyer and seller must share the cost of repair. No. If the property is damaged or destroyed prior to a legal title passing to the buyer has the option of terminating the contract. If the buyer misrepresents their financial ability, they are considered in default, and the seller has the right to terminate the contract. Okay, one is false. This one here. The broker is not responsible for the performance of any of their clients. No. If the property is destroyed, the buyer and seller must share the cost. No. No. They do not need to share the cost. All right. HOAs to leases. Okay. States that the property is not part of an HOA. All right, let's go to the bottom. States that the seller must not negotiate a new lease or existing lease that extends past the settlement or possession date. I'm guessing it's leases. States that neither the sales contract nor the buyer's loan is contingent upon the sale of another property. Is subject to ground rent. Okay, so I'm guessing this is ground rent. And this is lease, and this is sale. Let's try it out. No. Okay, so HOA ground rent is correct. This one is sale and settlement. I mean, it says it right up here. Duh. Okay. All right, so let's try it again. Ground rent. Sales contracts are designed to uncover contingencies or conflicts that could result in a sales transaction not being done. And this includes HOA fees, ground rent. All right. Contingency or lease of other real estate. All right, sales contracts default. All right, let's see what we got here. What constitutes a breach of contract? is to make full settlement in accordance with the terms of the contract. Contract defaults and deposit disputes. If a seller fails to perform or comply with the contract terms and condition, the buyer has the right to pursue all legal and equitable remedies, including specific performance or damages against the seller. If the buyer defaults, the seller may retain full deposit as long as the buyer and seller have a signed release of deposit agreement to that effect. If the buyers are in default because they failed to comply with the terms, they are automatically entitled to receive half their deposit. No, I don't think so. All right, if the parties do not agree to sign and release a deposit and the borrower is in default, the seller receives the full amount of the deposit. I think that's correct. All right, if there's any dispute or litigation, what happens to the deposit? The broker holds the deposit and to court handling. The broker who is holding the deposit is not authorized to take money, to file fees, court costs, attorneys. False. Okay, he can use that money to file fees, court costs. Okay, this one is false. Let's see. The statement is false. If the parties do not agree to sign a release and either party defaults, the buyers and sellers are free to pursue all legal and equitable terms. Okay, this is true, and broker can hold that deposit and pay, and true. What did I say this was? Buyer than unsolved, and the seller receives full amount. The buyer is in default, they are automatically entitled to half unless otherwise. No. Alright, I can't remember what I had before. This one's false. I think I got the same exact ones wrong again. Alright, let me take a picture so we don't get this wrong again. Apparently I'm not getting it right. Okay. Not going to get it wrong again, I'm telling you. Alrighty then. Because we got to move on. We're going to run out of time. Am I right? Okay. This one was false. All right, the buyer defaults, the seller is entitled to the full deposit if both parties agree to this and a signed release of deposit agreement. And this is for all states, by the way. And I don't mean all states as an insurance company. I mean all states in the United States as a realtor. If the seller defaults, the buyer can pursue all legal and equitable remedies. If the parties do not agree to sign or release a deposit agreement, and either party defaults, the buyer and seller are free to pursue all legal and equitable remedies. If there is a dispute or litigation between the parties as to what happens to the deposit, the broker holding the deposit can pay it in court, handling your dispute, and they can deduct the filing and court costs from the deposit. All right, let's take this exam and pray we pass it the first time. We are at 19 minutes. Okay, which section of the contract states that brokers in the sales transaction will be compensated? Okay, Hank just received notice that the seller, because the cost of repairs and damage caused by termites is more than 2% of the purchase price, she has decided to cancel the contract. What recourse does Hank have? I don't think he has any choice. All right, miscellaneous charges that would be adjusted the day of settlement are referred to in the residential contract of sale as Adjustments, or it could be addendums. I'm thinking adjustments, though, because it says adjustments up there. Okay, what section stipulates that the seller is conveying the property in a good merchantable title? Condition of property. All right, which of the following statements about a broker's liability according to the broker liability section is true? I think it's this one. They're not liable. Okay, according to the property and possession section of the residential, the buyer has the right to make a final inspection within 5 days prior to settlement. Which of the sections the seller is responsible for maintaining the property in the same condition as it is on the date a contract acceptance? Seller responsibility, maybe? Or it could be the condition. That's a tough one there. Okay, what following statements are true about the situation and having to pay the state transfer tax is true? They're a first-time home buyer, so more than likely they will not have to pay that. Usually the seller has to pay that if it's a first-time home buyer. What is the purpose of the default section of the residential contract? I'm guessing if the seller or buyer default. Okay. Which of the following responsibilities does the seller have? Keeping the title prior to securing financing. This is the seller's responsibility. It's not their responsibility to secure financing. Keeping the title free of defects. All right, we failed. So, all right, Hank has no choice but to accept this. All right, Hank can offer to pay for the amount. All right, the deed and title section. All right, I'm going to go kind of slow here in case you want to take some pictures. All right, this one here we got wrong, and this one is the seller responsibility section. Maintaining the property. And I think I put that on the other one. Did I get the other one right? Okay, the seller must pay the state transfer tax, but at a reduced rate. Okay. What was the other one I got wrong? Condition. I think I got that right in the other one. No, I got that wrong on the other one. Deed and title section is the good and merchantable title. Okay. And then the other one was the seller has to put the condition of the property and possessions. I'm getting ready to end this video. I will retake this test. Probably on my own this time. I won't record it because it says Maryland sales contract, and most people are not going to watch it. So I'm not going to do a whole video on it. I can probably get through it pretty quick. And I'm not going to do a video on this. But for those coming back, the next video in this line is sections of the contract part 2. So we'll see. All right. Thank you all for watching.